A very good evening to all who are present, all the participants. So I see there are people who are joining still. So can Maheshji, what should I do? Shall I wait for more people to join?
Yes, sir. You can wait for a few minutes, sir.
Okay.
Yeah.
Okay, so maybe I will start, and as and when people join, I can take questions and answer them. But the participants who are present, if you have any questions that you need answering, you can unmute yourself and ask. So I can answer that right now, or as you please, you can ask it later as well, or write it in the chat box. So let me just share my PowerPoint presentation, something I prepared for today. I hope this is visible to everybody. So I think by now, there are 4 weeks that have been completed, 4 weeks of sessions. And in these 4 weeks, the participants have been understanding subject matters of copyright. So literary works, artistic works, musical works, dramatic works. You've been understanding how these subject matters come into existence, what are the various attributes of these subject matters. Also certain peculiar kinds of expressions and um, how they uh, are found within these categories of subject matter. These are all things you are understanding. So something I thought I will take up for our discussion today is whether personality elements, personality elements can be considered as works. So this is important because there are many concerns nowadays whether the name of a person, for example, can be considered as a copyrightable work, and if it is copied by someone without the authorization of the person whose name it is that a copyright infringement? In fact, one of the questions that was posed in the Google form that was circulated for this live session, one participant had asked the question about what is the difference between musical copyright and voice copyright. So that also gives credence to this discussion today, which is whether something like a person's voice can be considered as a subject matter. And if it can be, then what kind of subject matter would it be? So let us consider an illustration, and we will build on this illustration and try and answer questions concerning copyrightability of subject matter. So this is the illustration. X is a 20-year-old IT professional who's based in Mumbai. He was specifically clicked by Z, an amateur photographer at a cafe in Bandra. The photograph was taken without X's authorization. This is the basic fact situation. Now, if we add some more facts to this, then X is not a famous person. Z intends to publish this photograph in a digital collection, which he is going to call a candid picture of Mumbai. And from this album, he is going to be monetizing every element within it. This will also include the photograph that Z has clicked of X. So consider these issues. The first issue is that X does not want this photograph to be published at all. But the second is that he doesn't mind if this photograph is published, but he would like it if there is a negotiation as to royalty sharing or revenue sharing. So if you see, there is a distinction of perspective between the first consideration and the second. The first consideration essentially involving a non-economic consideration. That is, it's not like X wants any money from Z. X is only interested in having this particular photograph taken down or not utilized. And if at all it is utilized, it should be with X's express authorization. And the second perspective is a economic perspective, wherein clearly there is a sharing of revenue that X requires from Z. So if we look at the first perspective, the first perspective actually takes us through the right to privacy. So a basic question that we can ask ourselves is whether any one of us would wish to be photographed without our authorization, right? So in this case as well, X is not a famous person, so there is no real reason why anybody would want to photograph X specifically. So he could be very well having a personal moment, even if he is in a public space. So him getting photographed is something which is clearly not something which he has consented to. But we can clearly make a distinction between a person like X who is not famous and a person who is famous. So a famous personality would obviously um, there would be a lot more public interest in taking such a person's photograph, and the reasonable expectation of this person for privacy in a public space is considerably limited. But that doesn't mean that in a public space this person cannot enjoy, a private sphere. So let us consider a case that involved this particular model. Her name is Naomi Campbell. So Naomi Campbell was engaged in this particular case, Campbell versus Mirror Group newspapers. Now, in this particular case, the fact situation was very simple. Naomi Campbell was going through some tough period, and she was undergoing rehabilitation for a drugs problem that she was going through. And the fact that she was stepping out of the rehabilitation center, she was photographed, and there was a publication of this photograph. So the question was whether Naomi Campbell's privacy was breached. So quite obviously, the opposition here is that Naomi Campbell is a famous personality, and she can't be claiming a private space and public space. So something that is very important in this particular decision was how the court explains that there is a competition really, or a conflict that arises between the freedom of speech and expression that the photographer would enjoy, essentially, which is being propelled by public interest. At the same time, the um, the right to privacy of such an individual, and whether there is any privacy angle to such a famous person. So something that the court had explained was that there had to be a balance between the exercise of freedom of expression and the right to privacy. And even in cases where the person was famous, then there had to be a proportional exercise. So what this means is that that even if such a person like Naomi Campbell is in question, because in that specific situation she clearly did not want to be photographed. It was a personal moment, and for it to be photographed is actually a breach of her privacy, and therefore even famous persons have a reasonable expectation of privacy, considering the circumstances in which that particular photograph was taken. So, if this is the consideration with famous persons, then clearly we can say that the reasonable expectation of persons who are not expecting to be photographed, in whose photograph there is no real public interest, they would have clearly a wider range of protection of their private space. So, if you were to ask yourself this question, would you object to a photograph being taken of you without your consent, and the dissemination of this, distribution of this without your consent? And what kind of objections, or what kind of context would raise objections in your mind, and what kind of objections will they be? So, which is where we had taken a look at these two perspectives. One being a perspective where there is no real economic consideration that X wants, but rather is only interested in it being taken down. And second, the economic consideration. The second perspective, which is not a, like I said, an economic perspective, not a non-economic one, where there is a negotiation that this person is looking to achieve with respect to revenue streams. A question that can arise here is whether there is a copyright angle or the performer right angle. So performer rights is still something which we are yet to do. It's coming up in the upcoming weeks, but we would rather focus on copyright because the subject matters are something that you have already gone through in the last couple of weeks. So because now you understand copyright is a economic right, and in order for copyright to attach, there must be a subject matter. So we have dealt with literary works, musical works, artistic works, and dramatic works. So let's consider the first question, whether in considering personality elements, whether the name of a person can be considered a literary work. So you would recall that when you were doing when you were looking through the videos of the first week and understanding literary works, we were understanding that a literary work is basically any expression which uses words or numbers or symbols or other such indicia. You would recall the US copyright statute interpretation. So by that application, because name uses letters, it is a word, technically it is an expression which can satisfy a literary work consideration. But you would also recall that in order for literary works to exist, then we must put it through a kind of a examination of whether there is any informative value, or it is serving any instructional purpose, or whether there is any literary pleasure that's involved. So in a name, when somebody's name is used, so the question then is, what exactly is it about that person that is being discussed? Is it that, say, for example, the name is my name, say it's Rohan. So if simply the name Rohan is is what's being considered as a literary work, then the question is, what is that distinctive information about Rohan which is being expressed? Is Rohan having coffee? Is Rohan climbing a mountain? Is Rohan walking to the supermarket? What exactly about Rohan is being expressed? So merely providing the name does not really give any definitive information, and clearly there is no literary pleasure that can be derived from it, nor can there be any instructional purpose that we can highlight. So therefore, we cannot say that X is a literary work. So because X is not a literary work, there is no real question of whether copyright can subsist in a person's name. So a secondary consideration that we can think of is, even if we say that X could be considered as a literary work, there is also the question of who is the author of this name. So it will clearly not be the person whose name it is, because at the end of the day, the name is the work would be considered as a literary work originating from the person who has made that expression. So it would not be the person whose name it is, rather it would be parents who have given such a name. So coming to the second query, what about a person's image? So a name would not be a literary work. What about a person's image? Can that be considered to be an artistic work? So when we say a person's image, we are saying that physical attributes of a person. That's the person's image. So is physical attributes of a person an artistic work? So again, as we have discussed, artistic works have been expressed as graphical works. They can be sculptures, they can be works of artistic craftsmanship, architectural works. But in all these situations, there is an expression which is visually perceptible, right, and which is made by the artist. So in this case, there is no specific individual who is responsible for a given person's physical attributes. In fact, physical attributes are very natural, so to speak. So clearly, this we cannot consider this as an artistic work. If at all, if we are to take the question of authorship as we were considering it for literary works, then for artistic work, if at all somebody had to be an author, it would have to be God, because it's God who created everyone. So it would make sense then to attribute authorship to God. So these kind of questions would arise if we start considering things like personality elements as works. So what we can say is that X's image is not an artistic expression. And the third consideration, which is what about a person's voice? Can we say that a person's voice is a musical work? Now, in the week concerning musical works, we have understood that musical work has been interpreted by including aspects of graphical notations, for example, but music itself has not been interpreted within legislations. So, for example, under the Indian Copyright Act as well, music has not been defined. But what we have also understood is that instruments, the use of instruments, is basically a means to create music. So, music, if we say music is composition, then composition can be made through the use of instrument. So similarly, we can say that voice is a way to create composition. So when a person uses his voice to compose, then it's a medium to create musical work. But the voice itself cannot be considered as a musical work, because the voice is clearly not an expression, right? It is somebody's inherent personality element. It is something which is natural. And if at all it is anything connected to musical work, as I was explaining, it can be a medium. It can be a medium to create music. So clearly, all these three elements, be it voice or name or a person's image, none of these can be considered to be copyrightable works. Why? Because they cannot be considered as works. Right? So, yes, Prerit, please tell me your question.
Sir, regarding this voice thing, like as we are not attributing copyright to it because it is not it is not an expression. But regarding this, there are like mimicry artists and people who use voices of famous people for maybe for some performance only, or some ads, or some people may use them directly or indirectly, or through or in cartoons they are used. So at that time, do they violate any of the rights of the person?
Good,
For
good.
example,
Okay.
one just to add on it, once a few years back, I saw a news on Amitabh Bachchan. Like he was trying to, or like proposing of copywriting his voice, because his voice was being used like without his permission in some ad or something. So regarding this, I had a question.
Thank you for this question. So, a person's voice, such as a celebrity's voice, it can be used as a trademark. It can be used as a trademark, and it can generate sufficient reputation even under common law of passing off also, that can be a remedy, because a person's voice can gain sufficient reputation or goodwill, and it can be used for products or services in the market. So that can be an intellectual property that can attach. So another consideration that we can think of is the personality rights consideration. Personality rights, which is coming through the right to privacy angle. So in terms of copyright, there cannot be a subject matter in existence. This is important to understand, because a person's voice is not an expression. Nobody has expressed that voice, okay, a person's voice. So nobody is an author of a voice, but the voice can be used to make a composition. So you took the example of Amitabh Bachchan. Now, say for example, Amitabh Bachchan uses his voice to recite a poem. Okay, so the poem is a literary work, and him reciting the poem is basically a performance, which to which performer rights can attach. But the voice itself is not copyrightable, and for which there can be no performer right. So, is there a remedy to answer your question? Yes, but it is not in copyright. It will be under the common law of passing off or under trademark if it is registered.
Okay, so only if he registers under trademark or personality rights or any other person, then only.
Or under passing off also.
Yeah.
Passing off, unregistered marks are also protected.
Because there are many mimicry artists also who just use for their performance, mostly like if it is private concert you may not know, but because now on public shows also, on TV shows also, these people do. So it's up to that person that if he wants to file.
Absolutely, absolutely right. Yes.
Thank you.
Okay. Yes, Mr. Swayam.
I'm asking about that the voices of a person used in a cartoon characters, like in so many cartoons, the same character, sorry, the same person gave their voices to the character. So there might be a copyright problem, like by anyhow of means.
The voices that are used for cartoons, so these are basically being done by voiceover artists. So, so basically, say for example, in the studio, so there will be an animation that will be made, and in the studio, the artist will provide their voice, right, which will be synced with the visuals. So when the recording is made, when the animation recording is made, then the recording itself is a copyright. So that will be a cinematographic film, and the person who has provided that voice, that recording is basically a performance recording. Okay, but again, the voice itself is not copyrightable. Voice itself is not copyrightable. Voice itself is not performer right. Okay. It's the expression. The expression will be. Okay. Is that okay?
Yes, sir. Okay, thank you.
Okay. So, having dealt with subject matters, let's on copyright. Let me just briefly touch on performer rights. This is something that you are yet to study in the upcoming week, because performer right comes under related rights. But just to give you an example of continuing from what I was saying before. So a performer right is basically linked to copyright, or it need not be. But if there is a copyright in existence, so if there is a literary work in existence, for example, a poem, and the poem is original, for which there is an author who's enjoying copyright, then performance of that poem is something which has to be authorized. So that's a copyright which will be exercised by the author. But in performances, so when a person sings, for example, when a person sings or recites poetry, then it is the performance. It's the performance which will have a right, but not the medium for which the right will exist. So, similar to voice, we can also consider guitar, right? So, a person can use a guitar to perform. That doesn't mean that the guitar itself has some kind of copyright protection or performer right protection. It will be the way in which expression is produced from the guitar. Right? That's something which will be under copyright protection or performer rights protection. Okay, so hopefully this is clear to all of you. That and this is important because these are questions which are coming up a lot in contemporary discussions, whether a person's personality elements can be copyrighted or not. So this is basically what I wanted to take up today in the live session. There are very few questions that were raised by participants in the Google form that was circulated. Just I think one or two comments were added. One was the difference between music and voice copyright. I hope that question has been answered. Another query that was raised by Mr. Arjun um, was that his professor has suggested that copyright can provide for a side income, and something that he wants to understand how it can provide a side income. So I just want to touch on that slightly. So the idea of commercially exploiting a work and earning from it and developing a revenue stream is basically connected to creatively generating expressions. So if you have a creative side, if you like writing, if you like singing, if you like playing an instrument, then these are all avenues through which a work can come into existence or a performance can come into existence. And once they do, then revenue streams can generate. So there are certain cautions that must be kept in mind. So one is clearly that if you are a performer and if you are a singer, for example, then if you take someone's lyrics and composition and then perform, if you look to commercially utilize it, then you could be violating the person's copyright. So it's always better to take prior permission. Once that prior permission has been sought and a negotiation for revenue sharing has been established, then there is obviously a revenue stream that will arise. So Arjun has also asked how, revenue streams can arise from patents and from trademarks. So that's not particularly connected to our subject of study, but just to give a brief understanding, trademark is connected to businesses. So if you are running a business, then trademark will basically help protect your the indication of source of your business in the market. So as goes for your products and services. So if you have a business, if you're running a business, then trademarks can help there. Patents are more complex because there has to be an invention. So if you are a technical person, if you are inventing something, then a revenue stream can attach to that. So these were the only questions that were there in the Google form. For the next live session, please raise more questions. Yes, Swayam, I see your hand is up. Please ask.
So I have a question that you said that we have to take up prior permissions before using the lyrics or a music of anyone. So at the platform of the YouTube, we have a some time gap for any music. like for that time you have playing that music, you don't get a copyright on your videos. So that the platform is able to like have right to that you have that time to not we are showing for the copyright, or the author or the person who have their rights of their music or a lyrics, so they have a like authority to take that how much time we could give the another one to play our music or using our lyrics at in their video.
Okay, YouTube will basically, so when you try and upload a video on YouTube, say for example, it is you are singing and you are including someone's lyrics and composition. So YouTube will basically ask you whether, it will detect that there is a possible copyright violation. It will ask you whether you have permission. And if you click yes, that you have permission, then it allows you to upload it. So this doesn't mean that once it is uploaded, it cannot be the subject of a strike. So the copyright holder, say the lyricist, can go to YouTube. He can see this video that you uploaded. He can notify YouTube that this is an unauthorized upload, and then YouTube will engage in a strike. It will engage in a takedown. So this takedown will usually be in place uh, until there can be a, there can be some kind of a court remedy to defreeze such a takedown or to extend such a takedown. So the intermediary's liability is actually involved more when there is knowledge of infringement. So this is something which has been established in many cases. So in fact, I think over the course of your study as well, we touch on intermediary liability. So it's always better, I think, to take prior permission. If you know that the lyrics are original lyrics, then it's always good. But having said that, many lyrics and compositions, they have fallen into public domain. So it's okay to use them, or some creators are okay with you attributing them and not really giving them any economic incentive. So that is there also. But yeah, that's the issue. So did that answer your question, or was there any other angle to it? Yes, Prerit, please.
Yes, sir. This question is regarding drawing, actually, drawing and photographs related. So there are two things. One is when we say, when we talk about photographs and we say there should be some uh, special thing that photographer has done, either some light setup he has done or taken photograph at a certain time, which is not reproducible or something. Similarly, for drawing, sometimes we like sketch artists or people draw from photographs of celebrities or some photograph basically. So, how do they make sure that like, because some people just draw as hobbies, so will they be coming under copyright violation, or is it just if you are just drawing and posting as your art, it is fine? And one thing, if someone has, like, when we say drawing as an artistic work or any type of drawing or painting, now is it the theme that is more important? Because same thing, if one person has drawn using only one medium, say pencil and some pencil or graphite or charcoal, and some other person draws the same thing but in some other medium, say oil pastels or oil colors, so do they will they get a benefit of copyright separately, or is either of them violating others' right?
Okay, those are some good questions. So let me take the first question, which is what happens if you use a photograph and use that to make a drawing? So technically speaking, this should not amount to any kind of infringement, because you have transformed the expression. So later in your course, you will be studying about fair use. So one of the things in fair use is whether you are able to transform a work. So when you create a drawing, you have essentially changed the purpose of that particular expression. So it's no longer connected to the medium, which was the photograph, not serving that specific market. You have changed the market also, right? The second question you asked was about what happens if you change the nature, right? So what if it is by pencil and you change it to something else? Now, here also there can be a question of transformativeness, but here I think there can be an equally strong contention about adaptations. So, an adaptation can involve the use of, say, a different, different means of graphic art, of making graphic art, like painting, for example. But the issue with graphic art, especially, is that because it is so technical specific, it's technique specific. Drawing is very, very technique specific. So is painting. There are many different types of paintings, and they're all very technique specific. And as you have studied in your course as well, artistic work has evolved to provide copyright protection for these specific skills and these techniques. So the originality component is attached to the skill. So it's a very high chance that you will be able to get a copyright protection for by the way in which that expression happens. That's a very high chance. But can there be a claim for infringement? There can be. So there can be a question of adaptation and unauthorized adaptation. But these are good questions. Yeah.
Thank you, sir. So what I understood is, like, because photograph and drawing in between, they are totally different, have totally different audience. So their adaptation can still be accepted, but within drawing or within art, because medium difference may sometimes lead to copyright infringement.
Correct, correct.
Is it?
In the
So
first situation, it will be more of a question of fair use. So fair
yeah,
use is an exception. So
okay.
transformative is correct. Yeah.
So if we say from photograph to drawing or other drawing or painting, it has come to a different adaptation. Then in case of literary work like book to a film adaptation,
Mm.
we have heard that still the film people need the rights from the writer, even though they are just changing, transforming. Again, here also we are transforming into very different domain. So don't same laws like same things apply for both.
No, because in that situation, there is a specific copyright which is different from adaptation. It's called the copyright to make a cinematograph film. That's
Yeah.
not an adaptation right. That's a separate copyright. So that copyright is not considered in the previous example. So that's why that is more problematic.
Hmm. And so in the law, in that law, it is like cinematographic film is usually mentioned many
Hmm.
times.
Hmm.
But does it need to be modified, or does it already cover the current modern medium of digital records? Because cinematographic film was usually like celluloid, and these things were specific material, and these were names were used for those.
Hmm.
But because many times people take advantage of words in meaning, so like you can say that okay, digital is something different or internet is something different, and can these things be exploited like this, or do they already cover it?
It covers it because
Okay.
it is very clearly provided in the interpretation of cinematograph work
Hmm.
that any process analogous to
Okay.
cinematography is also covered.
Okay.
So it's very, very well covered. And in section 14 also, it is very clearly stated that, where there is reproduction in any form, it could be an electronic form also. So that is covered within copyright.
Okay. So in future, if any new form comes, we can expect that it is covered.
Digital forms, yes, but
Yeah. Okay. Some,
there
yeah,
are, yeah,
we
but
know.
we don't know for sure
Yeah,
what
that's,
new form will come. But
yeah,
digital
because
forms are
now,
common.
like in AI, people are making use of AI or
Mm.
machine learning models. Now, those are working actually on previously released data only, like previous data of original artists. Now, for example, recently Ghibli art imagery was getting famous, but that original artist was had some. Maybe I'm not sure he had a copyright or it. No, but in general, artists. Original work is being used, or any literary original work is being used to train the model and to generate something, and many of the times it can be taking element from them. So does it violate their copyright, or are they able to protect themselves from this?
Excellent,
Okay.
excellent question again. So basically, data sets can involve a lot of infringing copyrighted material.
Yes.
So the outputs generated by AI tools, they should
Yes.
always be verified, like
Yes.
verified and seen whether any infringement has happened. The example you gave about Ghibli art. So Ghibli art essentially was a question concerning a specific technique of art. So techniques aren't covered under copyright law. Specific expression is.
Mm.
So the question of copyright infringement arising purely because you used a technique is very low. I mean, that will not arise. But can an artist claim copyright infringement because a tool, the output given by AI tool is substantially similar to his piece of art? Yes.
Oh, okay, sir.
Yeah. Okay. Anything else? Anybody has a question or a doubt? So, what I can possibly suggest and request is that for the next live session, please please pose more questions because it helps me, not give you a presentation particularly, but focus more on clearing your doubts. And some very good doubts were out, or questions were raised today. So thank you to everybody who participated. If there's anything else, I can wait for maybe 1 or 2 minutes. I can wait for any questions from the participants, and then we can probably exit for the day. Okay, then. Thank you for joining. Hope you guys are all enjoying the course. And hope you keep enjoying. See you in the next live session. See you. Bye.